Here's tip number 1 for an amicable divorce. Communicate to your spouse that you want a divorce before filing divorce papers. There's no reason to give them shock and awe. Whether you're doing an uncontested divorce or a default with written agreement, both parties still need to do their financial disclosures and file the FL 141. If your judgment gets rejected, the court is not going to tell you every and all issues that you have made. They're going to make the most apparent observations and write that up in the reject letter, but expect it to be rejected multiple times following that. Don't feel bad if your divorce judgment gets rejected. Half our business comes to us who have tried to submit their judgment multiple times and it's been rejected multiple times. There's help. We can help you. Give us a call. Usually just takes a few days to finalize your case. In the past couple of weeks, we've taken on 4 Sonoma County divorce cases. 2 are already approved by the court. Sonoma County processes their judgments very fast. If you need help with a Sonoma County divorce, give me a call. Today we took on 2 cases that were older, filed in 2020. Presumably because of COVID, they didn't finalize their divorce. If you have an older case, we can finalize it and take over and finish it for you. If you filed a divorce case years ago and never finished it, don't assume it's been dismissed. Give me a call. I can check the court website to see if it's active. If it's active, we can finalize it without starting a new case. Quick tip, to get a case number faster with the Santa Clara court, you should e-file your petition. Unfortunately, everything else has to be mail filed. Stopping child support has never been easier. If the parties agree, you can waive child support by signing and filing a non-guideline order. The biggest mistake people make when dividing property is thinking it needs to be divided equally. If you agree to an unequal division, the court will allow it. We just took on a new client who has quoted $5,000 for his divorce with no assets, no debts, no children, no nothing. There's a better way and a cheaper way if you're amicable. I file every single case that's in LA County in the downtown court because they handle the most cases and they have the most experienced clerks and we have the most successful divorce cases go through there. If you made contributions to your pension during the marriage, the court considers that community property even though it's in your name alone. If you are going to file the response to your divorce and there are minor children, you also have to attach the UCCJEA just like you do in the petition. If your divorce case is amicable, you're wasting your money literally by filing the response. Filing the response triggers a second $435 court filing fee. One benefit of the summary dissolution is you can easily revoke the judgment at any time within the 6 months of filing the joint petition. Do you want to know a secret to save $435 on your divorce? Don't file a response. In Santa Clara County, you can e-file the summary dissolution petition, but you cannot e-file the judgment. You have to mail it in. Here's a few options to use for the date of separation. The date you moved out. Maybe the date you moved up into the upstairs bedroom, or maybe a date you just agree to. That's fine as well. If you're thinking about restoring your maiden name even a little bit, I recommend you request that in the judgment. You do not have to go out and do it. You could do it 20 years later if you decided to. If you're going through a divorce and your spouse live out of country, make them the petitioner if your divorce is amicable. That way they don't need to get their signature notarized. If you e-file anything with Ventura County Superior Court other than the petition, you will not get copies. You'll have to call the clerk, pay a fee, and then they'll email you the documents. In Ventura County, you can e-file your initial divorce petition, but everything else has to be mail filed with the court. Today is June 13th. You only have 17 days left to file for divorce to finalize it this year. So I just took on another divorce case in San Diego County, and I love San Diego County because they allow us to e-file and e-sign and e-notarize all paperwork. The 6-month wait in California is known as the cooling off period, and it's there to give you time to reconcile your marriage. Today is June 14th. You only have 16 days left to file your divorce in California to be able to finalize it by the end of this year. If the request or default has already been filed and entered, and now your spouse wants to participate, you can still do that through a default with written agreement type divorce case. Even if you're going to keep 100% of a particular asset or debt in your divorce, you still want to list that as such on the settlement agreement. Even if an asset or debt is not in both your names, it still is technically considered community property if it was acquired during the marriage. Just because your spouse is not participating or filing a response does not mean you can keep all the community property. In my experience, the court has made us divide it all equally and they still will get half. Today is June 15th, which means there's only 15 days left to file your divorce in California to be able to finalize it this year. There's 3 types of divorce cases: uncontested, default with agreement, and default without agreement. It's almost too late. Today is June 19th, 2023, and you only have 11 days left to file for divorce to finalize it this year. I just filed another Solano County divorce case, and they do not have e-filing, but their mail filing is pretty fast. I mailed it in on June 7th, and it was filed on June 12th, so not too shabby. Quick update on the divorce child support order for your judgment. If you don't want there to be child support when there should be, make sure you write reserved and not 0. I was recently asked by a client if they could keep 100% of the family home, and the answer is yes, as long as your spouse agrees to it. The court doesn't care about the level of fairness in your agreement. As long as you agree, that's all that matters. The court will not interfere with your decision making if your divorce is amicable. If you're doing a default with written agreement, you still have to wait the 30 days after the date of service to submit your signed judgment for review to court. The only way to turn your judgment in for review and approval prior to the 30 days is to file a response. Then there's no longer a default and the judge can review your case. If you want to finalize your California divorce by the end of the year, you only have 10 days left to file. I just submitted another judgment for approval for Alameda County. These clients wanted to terminate spousal a long-term marriage. If you're trying to do the same, make sure to include the waiver language. You never want to file the FL 130 appearance, stipulation, and waivers when you're doing a default with written agreement type case. That's only for uncontested divorce cases. If you have different names listed on your driver's license, passport, and social security card, make sure to list those as AKAs when filing your divorce paperwork. If you're handling your own divorce case and you're not in agreement with your spouse, after you file the response, file a request for trial setting so you can get a hearing with the court. Don't worry about fighting over social security benefits when going through a divorce. You're already entitled to 50% of your spouse's benefit if it's more than yours and it does not impact the amount that your spouse receives. I just went to file a new case for clients who live in Victorville and just found out you no longer can handle family law cases at Victorville. You now have to file them in Barstow. The amount of time you've been separated does not count towards the 6-month cooling off period. If you have an amicable divorce, don't personally serve your spouse. Use the notice and acknowledgement form FL 117. It's a much easier way to go. Remember, the 6-month cooling off period starts at the date of service, not when you file the petition. If you don't want child support as part of your amicable divorce, that's not a problem through the non-guideline order where we can request 0. Even though it's mandatory, we can get you 0 child support. Every single client who has started their own divorce and then called me for help is trying to do a default without an agreement. Switch it to default with written agreement. The settlement agreement you sign with your spouse in your divorce will supersede the requests made in the petition. So if you made a mistake there, you can correct it in the settlement agreement. Terminating the court's jurisdiction over spouse support on the petition means no spouse support now or ever. Reserved jurisdiction over spouse support means no spouse support now, but possibly you want to request spouse support in the future. Default without an agreement means a response was not filed and the respondent is not participating at all. Default with a written agreement means that a response was not filed, but you guys are both going to sign the marital settlement agreement. When you file a response to the divorce case, it doesn't mean that your divorce is now contested. In fact, filing the response means your case is uncontested. There are 3 types of divorce cases in California: default with agreement, default without agreement, and uncontested. I'm just filing a new Alameda County divorce case, and I just noticed online that they will allow for e-filing beginning September 5th, which will greatly speed up the filing process. Before you hire a paralegal service for your divorce, make sure you guys are 100% amicable and cooperative. If at the end we prepare all the paperwork and then your spouse doesn't sign off, it blows up the entire process. You don't have to wait to be served to file your response. If you know there's an open and active case, you can file your response without waiting to be served. There's only 4 more days to file for divorce this calendar year to be able to finalize it before the end of this year. When you hire me, I know you want your divorce done fast. Because we use the e-filing system, we had 2 new cases and clients this morning. They've already signed their paperwork electronically and it's been e-filed with the court. In a true default case where there's no agreement, the judgment has to match the petition 100%. You can make no changes. In an amicable, uncontested divorce, it does not matter who the petitioner is. Whether it's a default with agreement or an uncontested divorce where a response was filed, the respondent still needs to complete their preliminary declaration of disclosure. Look, I get it. You want to save money, so you try and do your own divorce. You file the petition and then your spouse files a response unnecessarily because you're amicable. Then you end up hiring me anyways, in the end costing you more money. The way we're getting our divorce judgments completed and finalized by the court in 5 weeks is we don't turn it in phases. We turn in the entire judgment package, including the request in or default, with the judgment package. There's no requirement that you be physically separated prior to filing for divorce. In fact, most of our clients still live together when we file their initial divorce paperwork. Don't let this happen to you. We just had another call where someone got remarried and their first divorce was not finalized. It keeps on happening. Make sure your divorce is finished before you get remarried. It's all lies. A detailed parenting plan is not required in your California divorce. All you need to mark is joint legal, joint physical, and that's it.